The media industry's fight against generative AI's unchecked consumption of journalistic content reached a boiling point with the New York Times blockbuster 2023 lawsuit against OpenAI and Microsoft in the Southern District of New York. The Times alleged systematic copyright infringement on a massive scale. OpenAI scraped and used millions of its articles, spanning decades of investigative reporting, opinion pieces, and features, to train large language models like those powering ChatGPT and Microsoft's Copilot. Key evidence included ChatGPT's occasional regurgitation of near-verbatim Times content in responses, potentially diverting traffic and ad revenue while undermining the newspaper's paywall and subscription model. The complaint sought billions in damages for direct, vicarious, and contributory infringement, plus DMCA violations for removing copyright management information. Through 2025, the litigation advanced amid intense discovery battles and partial rulings. In early 2025 decisions, Judge Sidney Stein allowed most direct infringement claims to proceed, rejecting dismissal motions on timeliness and emphasizing publicized examples of verbatim outputs as evidence of harm. Preservation orders escalated, culminating in a December 2025 ruling mandating OpenAI to produce millions of anonymized ChatGPT logs, overriding some deletions, to probe infringement patterns and rebut hacking defenses. OpenAI appealed aspects internally while arguing fair use for transformative training. As of late December 2025, the case remains ongoing, with no trial date set but significant implications for fair use doctrine. If training is deemed non-infringing, AI developers gain latitude; otherwise, mandatory licensing could reshape data economies. Echoing parallel suits against companies like Anthropic and Perplexity, this saga tests market harm to creators, data governance, and compensation models.